It appears we've got Mr. Levenstein and Ms. Pohl both in the courtroom. Mr. Levenstein, we are ready for you when you are.
Thank you, Your Honor. Richard Levenstein of the Mason Yeager firm in Palm Beach Gardens, representing the plaintiffs, Dr. Flippin Trainer, and her obstetrical and gynecological practice, Caritas OBGYN. This is a case with significant and potentially wide-ranging impact upon physicians with medical staff privileges and the hospitals at which they practice. This is also a case with unprecedented facts as far as I can determine, because I've found no case where peer review procedures were fabricated by a hospital which did not exist previously to the peer review being conducted, as happened in this case. The defendants are not and never were entitled to the immunity from liability and the privilege of confidentiality that is provided otherwise to the peer review process pursuant to section 395.0193, subsection 7, or any other provision of that section, because the hospital did not comply with the written and binding peer review procedures it was required to have and did in fact have in its medical staff.
Mr. Levenstein?
Yes, ma'am.
Mr. Levenstein? I want to ask you about your theory of the immunity as to the state statute. What is the specific evidence of intentional fraud that you contend exists here?
Okay. As to intentional fraud, if that was required under these facts and circumstances, Your Honor, medical staff bylaws were in place governing the obligations and rights of physicians who were members of the medical staff of this hospital. Those medical staff bylaws contained a specific peer review process contained in dedicated articles of the bylaws, which specifically outlined the written and binding peer review procedures required for a hospital to have as a condition of licensure under section 395.0193, section 2, which we cited in our brief. By varying from the terms of those medical staff bylaws after my client had complied fully with them at every step of the process, up until the time the hearing committee reversed the medical executive committee's decision to summarily suspend her, she complied with what had been represented to her by the hospital as the peer review process required to be provided to physicians by law and in those bylaws. The hospital.
So your position essentially is that the hospital didn't fully comply or didn't comply with the bylaws, and that constitutes essentially a false statement by the hospital that somehow induced your client to rely on a state of affairs with regard to how the bylaws were going to play out for her. And I want to follow that with the question, because your client was given the opportunity to review the MEC's recommendation before it went to the board, to have that reviewed, and she didn't elect to take that, did she?
She did not, Your Honor, but I need to back up when you give me the opportunity.
Okay. Yes.
Because it's not that my client is claiming that there's an ordinary breach of the existing bylaws here. That's not the case. The bylaws were not misapplied because the terms and provisions that were imposed upon my client that gave the authority to the medical executive committee to accept or reject the hearing committee's decision don't exist in the bylaws. They were fabricated on an ad hoc basis after the fact.
You would agree that the bylaws don't vest the MEC with final approval, right? They have, the board is the part of the hospital that would make a final decision.
No, ma'am, I'm sorry, I didn't mean to interrupt you. No, ma'am, I would not. In this case, that's not the case. The bylaws in this case provided that in the case of a hearing committee decision and report, that only the aggrieved physician who would be the subject of an adverse action or recommendation or report by that hearing committee had the right to appeal it. The medical executive committee had no right.
But that's not my question. My question is that the ultimate blessing, if you will, that had to be taken with respect to the adverse action and what went through the committee, then to the MEC, The ultimate action on that did not come from the MEC, and the bylaws didn't contemplate that it would come from the MEC. It came from the hospital board.
No, ma'am. The bylaws don't contemplate that at all. The bylaws don't provide that the decision of the hearing committee, when it's favorable to the practitioner.
I'm talking about the medical executive committee's decision to reject the hearing committee recommendation.
The medical executive committee's decision to reject it was a decision that they had no authority by the bylaws, which are the written peer review procedures required by law.
Bylaws did contemplate that there was a recommendation by the hearing committee, not that the hearing committee has final say. The final say comes from the board.
Your Honor, that would be the case if that's what the bylaws.
And under your damages claim, you still have to somehow come up with some intentional fraud under either the federal statute or the Florida state statute in order to have any kind of claim at all.
That would be true, Your Honor, if within the written and binding peer review.
And at best, it seems to me what you have is you've got a situation which arguably fell through the cracks of the bylaws and wasn't discovered, but that isn't the first time that that's happened. We have case precedent where that has happened in the past. And it doesn't make it fraudulent because they came up with a process to fill in the eventuality of a favorable report.
But if that's the case, I'm sorry, but if that is the case, then the statutory requirement to have written and binding peer review procedures in place as a condition of licensure and the requirements to have medical staff bylaws as a condition of accreditation and operation of a hospital are meaningless. And physicians who are members of medical staffs can be subjected to ad hoc fabricated bylaws when the medical staff leadership or the hospital administration decides that the bylaws are lacking some element that enables them to overcome a favorable decision for a physician. Which
So
is
is it your position that what happened was intentional fraud?
It's intentional fraud because there's no provision in the bylaws for the medical executive committee to have accepted or rejected a decision that had been overruled by an independent hearing committee, pursuant to which the MEC had no right to appeal, only the practitioner did. And similar to the summary suspension provisions of the bylaws found in these same bylaws, a summary suspension can be terminated or reduced in time by the medical executive committee with no board involvement and no board action. That is not a decision that requires board action because it is not provided in the bylaws that it's required. And the same is true with regard to what happened to Dr. Flippin Trainer.
So you're arguing that once the hearing committee came up with its recommendation, that's the end of the matter?
Yes, sir, I am. Because
and if that's not so, then anything that happens after that is intentional fraud.
Then if that's not so, then the fabrication of non-existent bylaws provisions and the imposition upon them, upon a physician who had the right to rely upon what was in the medical staff bylaws, which is a contract between the members of the medical staff and the hospital, pursuant to the Sato-Longwood case, the Seeger-Longwood case of the Florida Supreme Court, the University Community Hospital case versus Wilson of this court, and the Lawler versus Wusthof case of the second.
Mr. Levenstein, I just want to pin you down a little bit on how I read the bylaws. One of the things that the Medical Executive Committee is empowered under the Section 2 of the bylaws is to make recommendations to the advisory board, including, but not limited to, review of and actions on reports of medical staff committees, which is what this hearing committee was. And that's what happened, isn't it?
No, ma'am, this is not a medical staff committee. This was a peer review committee.
But the hearing committee was convened at the direction of the medical executive committee, wasn't it?
But peer review is in a separate and dedicated article of the bylaws because that's where the written binding peer review procedures are found. Medical staff committees are found in a different article and they cover different subject matter specifically. Peer review committees are treated in the peer review article and nowhere else. So that the argument by the appellee that somehow medical staff committees report to the board or the MEC is not a valid argument when it comes to these peer review procedures, which are required.
Don't we have to read the bylaws as a whole, though? I mean, peer review is not a freestanding, completely independent function here.
But it has to be, Your Honor, with all due respect, because the statute which licenses hospitals requires it to be. And that's why.
It doesn't happen in a vacuum, though. It happens after
that,
something like a summary suspension that is within the purview of the medical executive committee.
And the medical executive committee has the purview to impose it. And as I said before, also has the ability to reduce it or terminate it without the involvement of the board, similar to what's in the bylaws with regard to the hearing committee, which does not give the medical executive committee or the board the authority to review a decision that's favorable to the practitioner. It only gives the adversely affected practitioners the right to appeal. The medical executive committee has no right to appeal the hearing committee's decision and the report. And if you look at the article dealing with the hearing committee, the word decision is used as well as report and recommendation. And there is no language that created the right for the medical executive committee to accept and reject the very report that reviewed their decision. And certainly if that right, which was a significant right with respect to my client or anyone else in that position existed, it had to be spelled out in writing as part of the written binding peer review procedures required by the law. And it simply doesn't exist. And similarly, Britt, you asked me about the appellate process that was offered to my client. That was also one that was fabricated for these particular circumstances because my client received a favorable result from the hearing committee that the medical executive committee, frankly, was not happy with for obvious reasons. And that process basically gave them the right to appeal that decision of the medical executive committee rejecting the decision.
Right, she could have appealed the medical executive committee's recommendation to reject the hearing committee's recommendation to reinstate.
But she's under the law as it exists, not required to participate in a procedure that doesn't exist and had no legal effect and was.
But it did exist. She was entitled to appeal the MEC's what was by then an adverse recommendation, and she chose not to pursue.
No, ma'am. There was no adverse recommendation because the medical executive committee had no authority to make any adverse recommendation. What the hospital did here was create an adverse recommendation by basically creating the right of the medical executive committee to review and accept or reject it. And we took the depositions of every person who was involved in the process. No one could point to anything in writing in the bylaws or anywhere else.
So at the end of the day, you put all this to the trial judge at a bench trial. We don't have the benefit of most of that transcript. And you want us to find that, or to review this and conclude that there was insufficient evidence that you proved an intentional fraud under the state statute and under the HICWA statute, the federal legislation, that the peer review process didn't comply with 1112. And we don't have much, if any, of a record from the trial to do that with.
No, ma'am. And I just forgot to reserve 5 minutes, Judge Silverman, if I can do that.
And you've got about a minute and a half to get to that point.
Thank you, sir. In response to that question, in the motion for summary judgment, we made these same arguments. When we filed our complaint, we laid all this out to the trial judge.
But you had a trial. And
yes,
what the evidence that was presented at the trial presumably was different, better, more, whatever, than what you argued for summary judgment. We don't have the benefit of that evidentiary record.
And you don't need to, you don't need to
have. Tell me why not.
You don't need, because this is a legal issue. Either the medical executive committee and the hospital had some authority, and they have not shown any that we are aware of, to have fabricated medical staff peer review processes that didn't exist and that were already complete in their written and binding form, which if they cannot, in our view, provide proof that they were authorized to do that somehow, and then impose that on my client and require her to avail herself of some additionally created appellate process, which was created out of thin air, then on a legal basis, they did not comply with Chapter 395.0193, which only grants immunity to a peer review committee or other body that carries out the provisions of that section. And if the hospitals, pursuant to section 3950193 subparagraph 2, did not have written and binding peer review procedures that gave them the right to do what they did to my client, they don't have the immunity as a matter of law. And it is clear that there is nothing that they've produced in writing that provides that authority.
You're at the 5-minute mark if you wish to reserve.
Thank you, Your Honor.
Ms. Pohl?
May it please the court, Beverly Pohl from Nelson Mullins, Broad and Cassell, for the hospital and nominally for the individual defendants, although the brief from Dr. Flippin Trainer seeks no relief from the individual defendants. I agree that the issue of whether further review by the MEC is not explicitly in the peer review section of the bylaws. I also agree with Judge LeBret that reading them as a whole, there are plenty of provisions that give the MEC that authority. But I think what's most important here is that this court doesn't really need to sort that out, because although counsel for Dr. Flippin Trainer has completely ignored the impact of the federal immunity statute for peer review proceedings, that this case can be decided solely on that basis without even getting to the state statute, without getting to the bylaws, without getting to intentional fraud. And I'll explain why. There are two key cases that are cited in our brief, Federal Circuit Court of Appeal cases. Wahi and Polliner from the 5th and I believe 6th Circuit Court of Appeals. And those cases say that federal immunity under the Healthcare Quality Improvement Act is not coextensive with compliance with the hospital's bylaws. That's not how it's decided. Under the federal statute, there is a presumption of immunity, a presumption that applies unless the physician rebuts that presumption. And here, when the issue of federal immunity was extensively briefed at the summary judgment stage by the hospital, the only response that Dr. Flippin Trainer had was a 2-page response making the sole argument she has made from the beginning of this case, which is this didn't comply with the bylaws. But that's not a response under federal law. She made no other argument as to any of the factors that are pertinent under federal law. And they're set out in our brief. They're set out at page 27 of the appendix to our brief, and they're all reasonableness factors. And the fact that the bylaws may not have been followed to a T doesn't matter under federal law. And what I think is telling, that when we made this argument quite clearly as our primary argument in the answer brief, there is no response to that in the reply brief. Not one case is cited by Dr. Flippin Trainer in either her principal brief or in the reply brief dealing with the federal immunity. And really the federal immunity is dispositive here. The summary judgment order mentions it in passing. There's no question that it was before the court. There's no question that the trial court found that immunity applied under both federal and state law here. And if you look at the Polliner decision at the end, the Circuit Court of Appeals there said, we have no occasion to even address state law immunity because it's so clear under the federal statute. The same thing here. This court can decide this case without parsing the bylaws and deciding whether what happened here was permissible under the bylaws, because it doesn't matter under federal law.
Under the counsel, under the Bryan decision, the 11th Circuit decision, would it not have been incumbent upon your opponent to, by a preponderance of the evidence, rebut the presumption of reasonableness of the federal immunity statute?
That's correct.
I don't recall seeing any effort to make that case.
There's nothing in the trial court record, and there's nothing in this court, because they have taken the position at every stage, at just they have one argument in this case. Their one argument is that the bylaws didn't provide for any review once the hearing committee ruled in her favor. That's their argument and that's their response. And it doesn't matter under the federal case law. So, I mean, the hearing committee.
I found it persuasive, the case that you cited, Desai versus Lawnwood, about how to handle a situation where something isn't explicitly addressed in the bylaws. It doesn't mean there's fraud. It just means that there's a need to fill in the gap, which is what I perceive was done in this case.
I agree, Your Honor, and I think that Desai is important if you find the occasion to look at the state statute. My argument is you don't even need to go to the state statute, but if you do, simply applying the procedure that was applied in this case does not constitute intentional fraud. That would be our argument. Perhaps I should turn to the second point, which is his argument that injunctive relief should have been granted. I think there's a very high burden for an appellant who's appealing an involuntary dismissal and who doesn't provide a transcript to the trial court. The judge's order granting the involuntary dismissal, of course, said that the judge had relied on the evidence presented. And it was a 5-day trial, as I recall, and counsel has not provided this court with what it needs to review that decision under Applegate. So that alone.
Well, there is some evidence in the record about the doctor's capacity to rejoin the medical staff or to have her privileges reinstated, and that is that her clinical license, her license is restricted in a way that she's not eligible to practice clinical medicine. Am I right?
That's correct, but the only evidence in the record are the exhibits which support our argument.
Well, and the fact that her license is restricted would foreclose her from any equitable relief in and of itself, wouldn't it?
It would, because under the bylaws, you have to have an unrestricted license in order to qualify for privileges. I mean, and that's assuming that a court can ever tell a hospital, give this doctor privileges. There has never been a case cited by the appellant here suggesting that a court has that authority. I would
the other issue, and I think there is some evidentiary record for this, the hospital is no longer providing OBGYN services. Is that right?
That's correct. Obstetrical services. I'm not sure about GYN.
GYN, okay.
That's correct. I'm not sure that that's dispositive because perhaps she could have privileges. She's a physician. Maybe she could do something else. So my reliance is not on that, but that is one of the facts of record. But here's another one. She testified under oath to the Board of Medicine that she had no desire to practice clinical medicine. And
wasn't the plan that she's going to be reinstated and then resign immediately?
But you know,
that was her proffer.
An injunction is an equitable remedy, and a judge considering whether to grant an injunction consider all of these multiple factors, and her testimony that she has no intention of practicing medicine certainly undermines her theory that she has a clear right to relief for a mandatory injunction. I think you have to demonstrate a clear legal right to relief. So I think that very much undermines her entitlement to that relief, notwithstanding the fact that we have never seen a case cited in this case giving a judge the authority to require a hospital to reinstate a physician whose license is not even fully unrestricted. So I agree, and I said in our brief that there is a small window of opportunity if an order granting an involuntary dismissal is fundamentally erroneous on its face. And I don't necessarily agree that this one was, but the bottom line is there are alternative reasons to affirm this order under the Tipsy-Coachman rule. Most importantly, that she had no license and was not qualified. And I don't believe that the appellant has met its burden to show reversible error in this case. So I think I've used up all my time, but for the following, all of the above reasons, we would ask that the court affirm on both counts, affirm the summary judgment under both federal and state law, noting that the appellant has wholly failed to brief the federal law question, and affirm the involuntary dismissal for lack of a record and alternative reasons for affirmance.
Very good. Thank you, Ms. Pohl. Mr. Levenstein, you have 5 minutes for rebuttal.
Thank you, Your Honor. Let me address the Desai case first that Judge Black mentioned. The Desai case has no application to this case. In that case, there was a written process and procedure, and that was my case that I was representing Dr. Desai in. In that case, the hospital board had actually created a written fair hearing and appellate procedure and not had the medical staff approve it and had attempted to impose it upon Dr. Desai. So there was a written document at that time with respect to that issue that was not in the medical staff bylaws. That was not a case where that document was created on an ad hoc basis for one physician, as in this case, where there was no written policy, but a verbal creation of what was imposed on Dr. Flippin Trainer. With regard to the HICWA argument, we're not arguing, nor have we ever, that the hospital didn't comply with their bylaws. Under HICWA, there has to be a bylaw that's not complied with that we argue about, because HICWA requires due process of law be provided to the physician. In order to have due process, there has to be some process that gets applied against the physician of which he or she is aware of in order for that due process to be applied.
Counsel, the two cases cited by your opponent, which is the Wahi case and the Polliner case, indicate that even if there is a non-compliance with the bylaws, the immunity still stands.
If it's you're correct, Judge. If we were arguing that they didn't comply with a specific enumerated provision in the bylaws, that would be non-compliance. But to create and fabricate non-existing bylaws is not non-compliance. That's something far different. The same way as in a contractual relationship between parties, creating terms that don't exist in a contract and then trying to impose those terms upon the other side of the contract is not a breach of the contract. It's a fabrication of terms that don't exist. And that's what we're dealing with here. And HICWA does not address the fabrication of non-existing bylaws because it deals with due process. And again, in order for there to be due process, there has to be a process. And there was no process in this case because it didn't exist until they created for Dr. Flippin Trainer. And that is contrary to the state law and to HICWA, because HICWA requires the physician to be provided with due process. And that's why we didn't spend a lot of time on arguing against it, because it does not apply under those cases or any other case that you will review under HICWA, because there are no cases in which a medical staff or a hospital has ever fabricated bylaws such as these that didn't exist before the peer review was conducted that we have been able to find, nor has the appellee cited to any such cases, because this is in my review, has never happened before that's made it into a reported case of any kind. And while HICWA has an objective test, this meets that objective test to challenge the due process that was not provided to my client, because there was no due process that was in existence at the time that the actions were taken against Dr. Flippin Trainer. They made them up as they went, so she had no expectation of what due process of law would be other than what was in the bylaws, which were the legally required written peer review processes the law requires. On the equitable side, the court applied the intentional fraud standard to the injunction we sought. Section 395.0193 does not require a showing of intentional fraud for the entry of injunctive relief. It's not there, simply does not require it. That's fundamental error. My client wanted to be reinstated to the medical staff pursuant to the order of the hearing committee, which she was entitled to have had the bylaws not been created to prevent that from happening. And she wanted to resign once she was reinstated, so she could resign in good standing and have the adverse action report that had been issued against her to the National Practitioners Data Bank vacated by the hospital, which the National Practitioners Data Bank in their guidebook acknowledges it is required to do and subject to the jurisdiction of state and federal courts to do when orders are issued. And you can find that in the guidebook clearly on page E8 of the National Practitioners Data Bank Guidebook. So what we were asking the court to do was within its equitable jurisdiction. Dr. Flippin Trainer was entitled to have been reinstated to the medical staff upon the completion of the hearing committee process. She was denied the ability to be reinstated then. She didn't lose that opportunity because the hospital fabricated peer review processes that didn't exist in order to defeat the finding of the hearing committee. If a hospital is permitted to engage in this type of a conduct, when medical staff bylaws are a contract between the hospital and the medical staff, and the Florida statute governing licensure of hospitals requires it to have written binding procedures, neither the bylaws nor the written binding peer review procedures required by the law have any value to the physicians or the hospital, because they can be changed on an ad hoc basis.
That takes us to the conclusion of the argument. Thank you both very much. That finishes the oral arguments for today's